software, there's actually an important passage, and that's the DMCA. And what the DMCA did is establish the rights for digital companies. And one of the important provisions is safe harbor. And again, it's this concept of being a landlord. How responsible are you for your tenants? And so some of the concepts that go into copyrights are fair use, what's considered to be a fair implementation, copyleft. Are you allowed to how do you redistribute? And actually the artistic look or feel for your digital interfaces, they're actually patentable. Now, one lawsuit was Viacom versus YouTube. And what Viacom did is they sued YouTube over copyright infringement because they claimed, hey, look, you're letting all these people pirate our movies and showing it on the internet. You should have to pay for it. And YouTube claimed safe harbor, that as long as they knowingly they did not knowingly have knowledge of people doing the wrong thing. So they're not behaviors. So what happened is the judge ruled safe harbor applies and YouTube won. And so they went back to court and they said, nope, there's enough here for a lawsuit. And so they went back to court again and YouTube won. So the moral of the story is lawyers can make a lot of money. But what it comes down to, though, is technology changes. And then the question is what happens to the original law? Because they're not directed at the specific technology. And so this is a challenge. In terms of international copyright laws, in general, the G20 respects each other's laws. There are different details to the laws, and this is where, you need to go get good lawyers. In terms of copyright coverage, these are the types of things that it copies, whether they're drawings, plays, any artistic works. Now, patents, what a patent is it grants you sole right to exclude others from doing what everybody else is doing. However, there's a trade-off to it, and that's that you have to publicly disclose what this invention is in its details. It also copies off of innocent copying, meaning more than one person in the world can come up with the same idea. So if you innocently copy it, that's okay. You're also allowed to reverse engineer it, and that means if you get something, you start taking it apart, that's not illegal. What is an invention? And it's new, useful, and non-obvious. It serves a purpose. You can't find it in the prior art. It's a patentable subject matter, and it's non-obvious. And this is one thing that drives me crazy. This provision has been so abused in the patent world, and that's person of ordinary skill in the art, posita. How do you define that, and what's considered to be ordinary skill? The thing about patents is they don't necessarily mean utility, meaning somebody patented the high five machine. One of the all-time classics is somebody patented bird diapers. Now, birds do take a dump in your car and all, so it is a solution to a problem. It does have utility. It's definitely original. But yeah, kind of a waste of time. The thing is, a patent doesn't protect your right to practice the invention. And so you can patent a rowboat, but you can't patent rowing. A patent typically will last for about 20 years. You can void if you don't pay your maintenance fees. Now, this is one of the patent rules that drives me absolutely crazy, and that's the America Invents Act. Boy, talk about a dumb title. But traditionally, patent law has always been about first to invent. And so if you have it documented or whatever, you can show, hey, I did it first. Now it's first to file. This really hurts the entrepreneurs, and it hurts the entrepreneurs because typically if you didn't have the cash, you could just wait to patent, and now you have to patent all the way. Now, there is something called a provisional patent, and what a provisional patent allows you to do is get 2 years out of it, meaning after you file a provisional patent, which is cheap, you have a year to file, and then after that you have another year before you have to do your full patent. But it's bad for entrepreneurs. It's bad for entrepreneurs due to the cost. So a provisional patent is a placeholder, and you have a year to file for full disclosure. However, the big thing about a patent is the priority date, because that establishes your rights. If your provisional patent doesn't line up with your full patent, and that's very well possible, because in that year things can change, your patent's voided. Full applications, those are expensive. Actually, one thing Professor Weissy does is he actually writes his own patents. Yeah, I don't have that level of guts. Some of the key concepts in patents are prior art, novelty, posita, and obviousness. These are the things that patents revolve around. There are different kinds of patents. There are utility patents. Those covers machines, manufacturing, design patents, and that's your design, like ornamental design. Those are typically good for 14 years. And then there are the plant patents. Why do they have special patents for plants? Well, when all this started, we were an agricultural society, so kind of makes sense. There are other patent types you also go for, re-examination patents. These are kind of like procedural patents, and that's if you want to review it again. The iPhone got rejected 4 times before it finally got accepted. And that really shows a difference between corporations that have cash and those that don't. Reissue patents, and that's if you find errors, but the majority of your patent still is valid. And additional improvement patents, and that's gee, I want to expand the scope of my patent, but it's really not big enough for its own standalone patent, so you just tack it on to the beginning. These are the types of things that are patentable. One thing I'll note is business methods are patentable. The problem is that they become so genericized so quickly. How can you really own the rights to something like Six Sigma? And so now business methods, you have to be tied to a technology in order to be patentable. Your patent, what is its power? It's your power from your willingness to defend it. If you get rejected because of posita, it's long and expensive. For startups, patents are good for property, weak on protection. And the reason why is you don't have the cash to defend it. A buddy of mine actually started a company. He wanted to create a low-power microprocessor. Very well respected in Silicon Valley, and raised $10 million for his company. Then Intel sued him, and they nuked him out of existence. He had to pretty much go out of business because he couldn't afford all the continued legal fees. Tough business. And for corporations, patents are mostly heads on a stick. They're going to be willing to defend it, and they have a lot of them to try to scare you off. Trade secrets are things that aren't known, and if you take reasonable measures to protect it, people are not allowed to steal it. However, with trade secrets, the only protection you have is misappropriation. However, the reason why do people keep trade secrets? Well, you keep trade secrets because you don't believe that anybody is going to figure it out. Like one of the trade secrets on one of my processes is that if you rinse 1 minute versus 3 minutes, there's actually a huge change in performance. How on earth are they going to figure it out? You can't do it through chemical analysis or anything else. But the big thing about trade secrets is your rights never expire, and that's why Coke has never bothered to patent their Coke recipe. When you think about IP, you have to think about timing, and that's that. For example, if you file too early, then you're going to waste years of protection just waiting to go to market. If you file too late, somebody's going to jump in and steal it. The general rule about patents is if you can reverse engineer a patent it, otherwise trade secret it, and does it align to your business? Some of the big lawsuits going that have ended is Waymo and Uber, and that's that Waymo, which is Google, one of their employees walked off with 14,000 files of data and also algorithms and everything else, and he went to Uber. And so they sued, and they ended up winning. And in the end, what they ended up doing was compromising, and now Alphabet owns part of Uber. There are trade-offs in IP, such as software, and that's that should I copyright it or should I patent it? And so software lawsuits can get really expensive because it's really unclear in terms of code. Do you have something really unique here? Or is it something that someone else had a right to copy? The thing about IP is your employees can be leaks, and so you have to keep them quiet. You have to be aware of the fact that the moment you publicly disclose your IP, the 1 year clock starts ticking. And it's actually really funny with my students, and that's that they go to all these contests and competitions. I say, be really careful what you say, because the moment you talk there, that 1 hour, 1 year clock starts ticking. And so today we talked about types of IP, capital, legal, trademarks and provisions, and trade secrets. And so that sums, I would, well, actually it's mandatory, but read Professor Weiss's lecture. He has some things on there that I don't have on this one, but I think this is a good general overview to tell you of what IP is.